Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business. Lee Kaplan, one of my favorite contributors, always look forward. I look for him on the radar screen in the days before he comes on because I kind of have a feeling when he's going to be coming back on. He's with Spicer, Kaplan, and Veselka. He brings great insight as well as energy to each of our conversations. Spicer, Kaplan, and Veselka, skv.com, is an awesome boutique law firm that has a big footprint in this town. Lee, talk a little bit about that firm before we talk about the laundry list of items we could talk about. Good to talk to you again.
Well, our firm does commercial litigation of all kinds, and we also do white-collar criminal defense work. The most notable white-collar criminal defense work is representing Captain Kaluza, one of the people in the BP oil spill case. And so far, the Court of Appeals has knocked out most of the government's theory, and the government's going to have to prove gross negligence on something, which I think will be virtually impossible to prove.
Well, good
work
on your part.
Area, what's that?
Good work on your firm's part.
Well, my partners, Sean Clark and Dane Ball and David Isaac, have done this for quite a while, and they are very, very, they're talented attorneys, and, there are ways to oppose the government in a professional way, and that seems to work a little better than having news conferences most of the time.
Yeah, no question about it.
On the civil commercial side, the most recent things we've been involved in have been an arbitration over oil and gas contracts, trade secrets theft lawsuit, which we tried, myself and Ty Doyle with another firm, and got a $12 million verdict in May, representing an automobile dealer against Hyundai in an Austin administrative hearing. We don't have a ruling yet, but I think we're done a pretty good job of demonstrating that the manufacturer discriminated against this dealer in allocation of cars. And of course, you need cars. If you don't have cars, you can't sell cars. And so we have a really wide range of litigation, and the people we hire, we hope, are really gifted people with a lot of moxie. We had 2 new lawyers this week, both of whom work for federal appellate judges. They're brilliant women, and they have hit the ground running. They literally started actually last Monday and have already turned out some work that's just astonishing how good it is. So
yeah. Well,
we're looking forward to the next few years.
That sounds like it. You gave me a list of items we could talk about before we got you on, but one we didn't talk about is what happened at the University of Missouri. I was wondering if you watched that at all. With the president
I'm not
resigning.
very well informed about that. I'm kind of astounded, though. The thing that's most
hold on one second, Lee, for the listener, real quickly, that there was a standoff between minority groups at the University of Missouri and the president. The minority groups demanding the president resign over reoccurring conflicts, is what I understand, to the point that the football team said that they were on strike. That's that's a pretty extraordinary situation, and the president did resign. I guess it was Monday. So go right ahead.
Well, and so is the chancellor. There is a little bit of a Texas tie here. The chancellor is a guy named Bowen Lofton, who came to Missouri from Texas A&M. He was, I think, a physics professor and very highly thought of, and they were sorry to lose him. He was apparently extremely popular at A&M, and now he went to Missouri and walked into the whirlwind. And so he's resigned, as well as the president, a guy named Wolf, and apparently the argument is that these individuals were not responsive enough to some racial incidents on campus. The only thing I've heard about is people yelling insults and a swastika being painted on some fraternity wall, perhaps. So I'm not very educated about this, but it is fairly interesting that the students could force this. Now, frankly, the football team getting involved, I think, is what really tipped the balance, because in the SEC, the football team matters, even
sure
if it's
does.
Missouri, which I think had a losing record.
Yeah, they're not doing particularly well. Not only that, there was a $1 million fine they would be facing on Saturday if they couldn't produce a team. And not producing a team, the implications are far-reaching. But I got to tell you, there's, you talk about, wag the dog. You got the student body literally driving a university like this. This seems like mobocracy, to be honest with you.
Well, I don't know enough about the underlying facts, but I do know that Bowen Lofton was extraordinarily popular at A&M, and it's hard to believe that he suddenly became somebody who didn't care about students and was insensitive to racial issues on campus. I just don't know anything about this gentleman, Mr. Wolf, or Professor Wolf, whatever, who was the president.
Mm-hmm.
But, yeah, I don't know if I'd say mobocracy, but when you lose the support of the entire student body, and the football team is part of that, because, football players are not thought of as a bunch of bleeding heart liberals, regardless of their race. But I gather the football team was fed up. And, often the football players are portrayed as the aggressors in various kinds of physical incidents and fights and things like that. So if the football players were upset, there may have been more to this than outsiders would suspect.
Something you
don't know about it.
Something you have been much more up to date on, and this story has been so moving, and I haven't even talked to you about it, but it really caught my attention, so I wanted to bring it to you. I appreciate your insights. It is telling, though. Well, I'm sure we'll be learning more in the weeks to come. But there is a major Supreme Court case, at least it is for Texans and people interested in civil liberties that you were talking to me about. Kind of give us an overview of that.
Well, the Supreme Court ruled in an excessive force case that and this actually happened in Tulia, Texas, although I think it was a DPS trooper, an officer stopped the car during a car chase by shooting. And in that shooting, the officer ignored the warning of the supervisor telling him not to fire at the car. He took a high-powered rifle to a highway overpass and shot at an approaching car, which was in this car chase, and he killed the driver. And the Supreme Court ruled 8-1 in an unsigned opinion. So 8 of them were, and that includes some very liberal justices, said that he had immunity unless unless it was beyond debate that his actions were unreasonable. And that's pretty astounding. In fact, they reversed the Fifth Circuit Court of Appeals, which had said 2-1, that the officer wasn't entitled to immunity. And, of course, the Court of Appeals is the Fifth Circuit is which covers Texas, is fairly conservative. And so 2 of them had said the officer was not entitled to immunity. There was a full in-bank hearing of the Fifth Circuit, and by 9-6, they said the officer was not entitled to immunity, and the Supreme Court reversed, with only Justice Sotomayor dissenting, and she said, basically, you guys are hollowing out the Fourth Amendment and sanctioning rogue conduct. This is a trooper who had no training in shooting at a fleeing car and literally was told, don't shoot, before the vehicle hit some spikes on the highway. And even more interesting, when the guy came back after the shooting, he confronted his superior and said, how's that for being proactive? So, notwithstanding all that, the Supreme Court 8-1 said he had complete immunity. That's a pretty interesting ruling.
Yeah, it is.
It's going to be a lot harder to sue for injuries that happened during a police chase.
Yeah, absolutely. A lot harder. What would you say, what's the basis for that decision? Because, sometimes the left and right will both agree, but they'll both agree for very different reasons, if you know what I mean. So what motivated it? What were the statements on the majority opinion, I guess?
Well, I guess what I would say is this. They've said, first of all, we've never before found the use of deadly force in connection with a dangerous car chase to violate the Fourth Amendment. It's long been known that you can kind of search a car because a car is mobile. There's no real expectation of privacy. You can, if you stop somebody in a car, you pretty much can look in the car and do whatever you want. Cars are treated a little differently from homes when it comes to unreasonable searches and seizure. And this is a different aspect of the Fourth Amendment, but I think they were just reluctant to say you've got to think real hard before you shoot at somebody during a police chase. And this is one of these bad cases make tough law, But I think the U.S. Supreme Court, particularly right now at a time when officers are sometimes being targeted, the Supreme Court, they say, is not political, but it is. And I think they're aware that police officers are under siege, and in this case they gave immunity to an officer who clearly violated his own superior's instructions and didn't know what he was doing. So that's a fairly astounding decision to me, but there is an explanation for it.
Lee Kaplan, he is with Smeisler, Kaplan, and Veselka. He's at skv.com. When we come back, we're going to talk about some decisions that were even closer to home that took place at the ballot box here on The Price of Business. Stay tuned for more right after this.